My name is Bob Thompson. I come to you as a conservative, often Republican-leaning business owner and rancher. And
there aren't many of you Austin Republicans, right?
No. I'm here to try to defend my property rights, which I feel are threatened by this bill. As a rancher, in our ranching operation, we're not anti-industry. We cooperate with oil and gas companies. We host gas transmission lines and electric transmission lines on our property. But we do pay attention to the leases that we sign and the right-of-way agreements, and we build into all of those agreements protections for our land. Most ranchers believe that the protection of their land from environmental harm is not only a sacred duty, but is their most essential private property right. And in order to be able to protect your property, it is essential to have the right to a full and unfettered participation in a contested case hearing process. This bill, in my opinion, goes in exactly the wrong direction. It takes the existing contested case hearing process, which already favors the industrial applicant over the landowning protestant, and changes the rules to further tilt the process even more strongly against the protesting landowner who is trying to protect his property rights. You've already heard numerous testimony that under the present rules, the TCEQ does not really function as a neutral party, but instead essentially functions as a handholder to the applicant, helping them to perfect their application. I have participated in a contested case hearing regarding a landfill application where water issues were predominantly important. And I can tell you that in that contested case hearing process, there are any number of complicated scientific calculations that have to be done as part of the application. There are hydrology calculations, there are surface runoff calculations, calculations regarding the aquifers, calculations regarding the geotechnical stability of the landfill pile, whether it's going to collapse or not. In all of those cases where all of these technical calculations are required, the applicant does the calculations and submits them in the application. The TCEQ technical staff provides absolutely no technical scrutiny or verification of the accuracy or correctness of those calculations. What they do is they monitor the application as it goes along to determine whether all the things that need to be addressed in the application have been addressed. And at the end of that process, the TCEQ technical staff and finally the executive director issues a finding that the application is technically complete. But being technically complete is not the same thing as being technically correct. And were it not for granting and receiving a contested case hearing and having the landowners hire their own expert witnesses to do some kind of verification and cross-checking, then there would be absolutely no scrutiny to determine whether or not the things that the applicant put in the application were in fact correct. And that's the only protection, that slender thread is the only thing that protects the groundwater resources of the state of Texas. And there's absolutely no doubt about that, because we have sworn testimony on the record of our contested case hearing where the technical experts of the TCEQ were under oath and were asked by our attorneys and by the OPIC, Office of Public Interest attorneys, did you do any calculations or any examination of any kind to try to verify whether what the applicant said is correct? And they said, no, we did not. We just presumed that the information in the application was correct. There were multiple witnesses that said that under oath, and that testimony can be provided to you, but there's no doubt about it. So it's extremely important that you protect the sanctity of the contested case hearing process and allow the protestants to bring forward new information, which is really indispensable. This bill, I guess the deficiencies have already been mentioned, but the shifting of the burden of the proof to the protestant is probably one of the worst deficiencies. If you're going to do that, what you're saying is that the applicant essentially has an entitlement to a permit, and only if the protestants can show that there's something wrong should he not be granted the permit. That's entirely backward from the way the process ought to work. There is no entitlement to a permit. Only if an applicant can show that he's complying with the protection of the environment and the federal regulations and state regulations regarding the environment should he be granted the permit. And I think it's irresponsible to lift that burden off of the applicant. The applicant has no entitlement to a permit. The executive director, as it is hand-holding the applicant. This bill has two provisions that would tie the executive director even more tightly to the applicant. You need to preserve some amount of neutrality within the TCEQ, and the issues about restricting discovery and not allowing new scientific information to be introduced after the period of technical review would be devastating in a complicated technical case such as I was involved in, because we were able to discover later than the end of the technical review numerous important facts that were not available in the application. I just don't see why you would want to curtail protestants from bringing forth important technical information that could have an important bearing on the permit, and even if it's granted, could lead to a better permit. So basically, I see this bill as an assault on private property rights. I think most ranchers, I know in the part of the country where we ranch, would view the situation very similarly. If you emasculate private property rights here in the state of Texas, I think you're going to be having people coming down here with pitchforks. It's bad enough already, and so I would urge you to not pass this bill.
Any questions of Mr. Thompson? Thank you for your testimony.